discuss GS paper 2. So first of all, what is the trend? The trend is, if any student just rely on the bookish knowledge, it is not going to be helpful. You are expected to follow the newspapers. The students who have been reading newspapers will be at advantage, and those who are reading and unnecessarily wasting time on the current affairs magazines, they may be getting certain facts but may be missing out lot of background story that gives any student the confidence to write the answer. So reading the current affairs magazine is, I believe, a harassment. Don't think it is essential, and go back to the basics. I will again recommend that if you will study the quality material, then only you can give the quality answers. Someone may look at the question paper and they may find it simple, but what appears simple, they may involve layered of complex truths, lot of background information, and I am happy that the students who have done the Polity PYQ class with me, we have very comprehensively covered the topics on corrupt practices in Representation of People Act. Again, the questions, some of the questions, I am very happy that even the students who will be, who are doing the polity classes, whether it is in our special 1250 program or elsewhere, even they will be able to do lot many questions, though we have done only few classes. And those who are doing my polity classes will realize how exactly I am not just telling, I have taught and so it has come. Because if it is a syllabus, everyone will cover that. But there is a big difference in how you should be covering the line of thought. So those who are doing GS polity, those who are doing polity 1250, you can understand how we started with the constitutional morality. So often students feel that from where this question comes, this is not given in Lakshmikant. Why are we spending so much time? Because that is common sense. So when UPSC will make the GS polity paper, of course, the well accomplished professors, lecturers from academics with the credibility will be making the paper. And anyone who is from political science knows that the study of constitution should begin with constitutional morality. And in the class, you must be remembering that I have emphasized on the constitutional morality of the judges, because this is what Ambedkar has repeatedly pointed out in his speech. So the idea is studying constitutional morality, but understanding the context in which you should study. I am very happy looking at the question paper, because if you know the flow of my class, from where do I start? The constitutional morality, and always the second question is on the judicial review, the role of judiciary. Again, what we see often, the students who have attended the classes previously, they may be at that point of time, they may not be realizing that when nobody in the institutes or nobody in the industry teaches union territories and its administration, why do I take so much interest in teaching union territories, going inside their laws, questions related to Jammu and Kashmir, Article 370, because these are the questions to be asked. These are the questions by which UPSC will test not only your current awareness, but your smartness. Fine. So, are you doing the things as usual, or you are somebody who has the knack of understanding? And I will show you how the questions are not factual questions. The questions come from lot of current affairs. So that is why the books like Lakshmikant, they can be helpful in solving 6 to 7 questions out of 12 in prelims, but not in mains. And again, the mains question, your answer depends upon your ability to deconstruct. How do you deconstruct the question? So now, what new you can bring? I always tell students to remember and to leave your distinct identity. The moment examiner looks at your question paper answers, your image should be there, your personality should come up. How do you deconstruct? How do you look at it? Is there an organic flow, or is it just enumeration of facts without context, concept, and understanding? So let us start the questions, and I will tell you, because it will be it will take lot of time, but let us see how much we can do. I will be telling you the approaches. So the first question is, discuss the corrupt practices for the purposes of RPA Act, Representation of the People Act. Means how under the Representation of People Act, corrupt practices are defined. And in Polity PYQ classes, we have done RPA very comprehensively, because normally it is not covered, and every year very deep questions come. Okay. Now, this part, analyze whether the increase in the assets of legislators or their associates, means family members, disproportionate to their known sources of income would constitute undue influence and consequently a corrupt practice. For your further reference, I have given the content which you can see later. But now, how should you have answered this particular question? And this issue of disproportionate income is everyday issue. We can talk about the case that is going on in Haryana against the late former Chief Minister Chautara. We can talk about the case going on in Uttarakhand against an MLA, Sandeep Awasthi or some Awasthi. There is a case that is going on against a member of Legislative Assembly in Tamil Nadu. So, not many cases are going on. And this is not new, because the problem of the money power and the muscle power is an eternal problem of Indian elections. And in the year 2018, there is a PIL filed by Lok Prahari in Supreme Court, where this issue was brought, and Supreme Court has made it clear and directed the government to put such things under the corrupt practices. But so far, it is not a part of the law. So this disproportionate increase and other things, right now, they are addressed under the Prevention of the Corruption Act, and indirectly, because MPs and MLAs, they also come under the definition of the Prevention of the Corruption Act 1988. So they are tried under it. And in Lok Prahari case, Supreme Court directed the central government, later on issued the writ of mandamus also, as they directed, to constitute a monitoring body as well as to bring changes in the law. So be aware, like you should be aware of the background stories. Now, what should be the first point? Discuss the corrupt practices. So obviously in Representation of People Act. So Representation of People Act is the key foundation of the electoral governance in India. And we all understand that democracy is India is not just a matter that matters to the people in India, but Indian democracy is observed with lot of fascination by the countries in north as well as south. And because the success of experiment of democracy is successful or is encouraging as far as India is concerned, there remains a hope that democracy can have a chance beyond the Western world. And in the era of representative democracy, the credibility and legitimacy of democracy depends upon the fidelity of the electoral system, and therefore, for the purpose of legitimacy, it is very essential that not only there is a law which prevents the corrupt practices to establish the level playing field in democracy, there is also essential that law doesn't have loopholes. From time to time, such law is reformed and is properly implemented. See, writing answer does not mean enumeration of the facts. The answer should reflect your understanding, your ability to connect the things, and it should come, you should understand the rationale behind it. Okay, and then you can discuss that section 123 of the Representation of People Act mentions various practices as the corrupt practices, like giving bribe, like using religion, like trying to have undue influence. And when you write about the corrupt practices, you should also mention what will happen if High Court under section 100 of RPA Act convicts and establish the corrupt practices. It may result into the disqualification. The person may lose the membership. So you should write as if not you know, but you understand. Okay. So what can be the consequences? Now analyze whether the increase in assets, fine. So from very beginning, we have seen civil society in India and Supreme Court in, like Association for Democratic Reforms has recognized voters' right to know and have held that under Form 26, a candidate should be declaring their assets, their financial assets, their criminal antecedents as a part of conduct of electoral rules. And this provision ensures that people will come to know about the disproportionate increase. Now, there was a case because Lok Prahari in 2018 has filed about and highlighted number of cases where suddenly there is a disproportionate increase. They demanded it should be recognized as undue influence, but as of now, it is not undue influence because the question is very specific under the Act. Okay, so judiciary has held that it will be against the constitutional propriety, but it is yet not directly a corrupt practice. Fine. So I hope you have understood what I mean to say, and this is for your reference because we don't have much time. So for your reference, you can see what is undue influence, systematic appeal, procuring, but directly no such things. Then this is a news from the Lok Prahari case. You can see it is there in Times of India, it is there in Indian Express and any newspaper. So the case was related to politicians, their spouses, dependents, now have to declare their sources of income along with their assets for contesting elections. Fine. And court has asked center to put in place a mechanism which periodically collects the data, and in case of any disproportionate increase in the assets, this committee is supposed to recommend the appropriate action, but still nowhere it is being pinpointed as a electoral offense, though Supreme Court held that it is constitutionally impermissible conduct, okay, and eventually constitute offense punishable under Prevention of Corruption Act. And it said that include certain provisions under the Rule 4A of Form Electoral Act and Form 26. So if you see Prevention of Corruption Act, within the definition of undue influence, it is not mentioned that this sudden increase, they have influenced. Ideally, you should explain what is undue influence. Fine. So undue influence means it violates voters' right to know. Okay. It violates voters' free exercise of the electoral right. So I hope you have understood the idea. You got the idea? So now this question, it is also essential that you understand why this question and what is the trend. If anybody will do the polity PYQ properly, they will get the fair idea and will be very close to the demand of UPSC exam. Okay. So we'll put some of the videos of that class so that you understand how you should be approaching the questions. So now, power of pardon on US President. And now let us first see the question. Compare and contrast means what are the differences? What are the similarities between president's power to pardon in India and USA? So what they want to know, not just facts, but the underlying principles. What are the underlying principles? Are there any limits to it in both the countries? And what are the preemptive pardons? This preemptive pardon was in news. Why it was in news? Because Trump has raised this issue. Fine. And the issue was in context of the former president, former president Joe Biden's son, Hunter Biden, getting the preemptive pardon, which is a practice in USA. We have given the notes, you can see in detail. Now this question should not just be answered in a factual manner, but it should also highlight the underlying principles. So and why this question? Why the comparison between US president's pardoning power and Indian president's pardoning power? And what is the difference? And the difference will emerge from where? The difference is going to emerge from the differential nature of the constitutional scheme and the political system. So, of course, Indian constitution takes lot many things from both Britain as well as from USA. So when we talk about Britain, in Britain, Queen is seen as the foundation of justice. And in Britain, the principle of parliamentary sovereignty exists. And therefore, in Britain, the ultimate power lies with the Council of Ministers, because Britain has the parliamentary system, and so long you enjoy the majority in the House, you have all the powers. And of course, the Queen in Britain is the constitutional head, but in, in the name of the Queen, it is Prime Minister's power, and Prime Minister enjoys lot of powers because there are no constitutional limitations on the powers of the Prime Minister in Britain, because it does not have the written constitution. Means they will the pardoning power, the scope of pardoning power in Britain is going to be bigger. And when power is bigger, the chances of misuse is also there. And often the pardoning power is also very politicized issue, because the executive may go for discrimination and they may not follow the rational procedure or the procedural due process. They may give pardon to the members of their own parties or affiliates, and they may keep on delaying the things if somebody is from different party or ideological background. So this is the context in which the Supreme Court in India from time to time has tried to elucidate the nature of the pardoning power of presidents and governors under Indian Constitution. So one similarity between India and US is that in both the two countries, the principle of constitutional supremacy exists. It means the type of leeway there can be in Britain to use the pardoning power more freely, that does not exist in the two countries with a written constitution. And you understand that the power of judiciary is comparatively limited in Britain because of parliamentary sovereignty. But the power of judicial review in case of India and USA is quite wide, considering the written constitution. So what we can say, that the pardoning power of the president in India and in US, it is all regulated by the constitution, by the letter and the spirit of constitution. There are obvious restraints. For example, the power of president, like if it is a state law other than, I will say, the death penalty, then Indian president cannot entertain or the request of pardon. Same is in US, being a federal system. So the powers of the authorities shaped by the nature of the political system. So somebody may be writing just facts, but how you can show your answer different if you explain the features and the concepts. So what will bring similarity? The similarity will be the written constitution and the federal system. And this is going to put the obvious limitations. And what will bring the differences? the differences will be because ours is not a presidential system. So in presidential system, president is the real executive. And when president uses the pardoning power, president is not dependent or answerable to the legislature. But in India, first of all, it is not president's discretionary power. President has to exercise this particular power on the aid and advice of the Council of Ministers. And of course, it comes under the parliamentary scrutiny as well as the scrutiny of the judiciary. So the minute and nuanced difference, the rest is the factual part, like in case of India, pardoning power of president under Article 72 deals with the death penalty, deals with the violation in case of any central law, etc. In case of court martial, certain facts, find similar facts related to US president. So I have explained the theme. First of all, either people will not write or they will write just factually, but what is important? Do you understand the system? Because we may not be knowing the facts, but we may be knowing and we should be knowing the fundamental principles on which the constitutions and the political systems are based. So what is required is you show your smartness, you show your intelligence, and whatever, if you are good in concepts, then how you will utilize those to show your level of analysis of the issues, your perspective of analyzing things. It has to be different and ordinary. It should not be ordinary. So did you get how to approach this? So for your facts, etc., I have explained. You can go through that. But all these things are of no use, right? This is meant for prelims. What is meant for mains is understanding. Fine. Now, this particular question. Discuss the nature of Jammu and Kashmir Legislative Assembly after the Jammu and Kashmir Reorganization Act 2019. Briefly describe the powers and functions of Assembly of the Union Territory of Jammu and Kashmir. So, first of all, again, show your analytical skills. Do you understand the underlying principles or not? Or you are going to just enumerate certain facts? The choice is yours. So how will I visualize this particular question? So what is Jammu and Kashmir now? It is a union territory. What was Jammu and Kashmir earlier? It was a state, but it had the state with certain unique features. So from where will I start this question? I will start this particular question that Article 1 of Indian Constitution says that India, that is Bharat, shall be the union of states. By telling that union of state, it talks about India's federal system. And what is the uniqueness of India's federal system? India's federal system reflects cooperative federalism, where center has the special powers. Same Article 1 also explain about the territories of the union, means union territories, as well as the states. It is the primacy of the center under Article 3 that Indian Constitution does not guarantee the territorial integrity of the states. And using Article 3, you can change, you can bring, you can go for reorganization of the states. Now, the entire question needs to be discussed under the second concept, and that is asymmetrical federalism. That all units of Indian Federation, they do not have the similar status. For example, there may be lot of variations among the states. There is variation between the states and union territories, and all union territories are not same. Now, the State Reorganization Act is a result of the constitutional orders which government has brought in 2019, where it has changed the governance structure of Jammu and Kashmir by bringing the change in the sense that Article 370, by which Jammu and Kashmir had its own independent constitution, has its own constitution, is no more existing. It is brought in a full-fledged manner under Indian state. So, as it has been a temporary provision, the final integration was pending, that is being done. Now, earlier, Jammu and Kashmir was the full-fledged state with the bicameral legislation. But now it is a union territory, and it is a union territory something at par with Pondicherry. It is, we have categories of union territories. From example, we have Delhi, we have Pondicherry, we do have Jammu and Kashmir, we have certain union territories which do not have the legislative assembly. So you should write your understanding of the system, because the syllabus is polity, system is important. Okay, and what changes have happened? First of all, it used to be the legislative assembly, but now of both, which used to cover the representatives from Ladakh region also. So now Ladakh is separated, and earlier it used to have the two houses, but now it has become unicameral. Earlier, the Legislative Assembly of Jammu and Kashmir, by virtue of Article 370, had certain special powers with respect to the subjects of the union list and concurrent list, which was not available with other states. And the Article 370 held that Parliament, like Article 370 was putting limitations on the powers of Parliament, requiring the concurrence of the state government there. But now it is a union territory, and earlier the residuary powers were lying with the Legislative Assembly of Jammu and Kashmir. But now, like all other states, even in case of Jammu and Kashmir, the residuary powers are lying with the union, and like Delhi and Pondicherry, certain subjects like police, law and order, and now even services are excluded from the state list. So, patterned on Pondicherry and Delhi, these changes are, and of course, because they are union territories, means the legislative assembly's powers will be under the greater control of the lieutenant governor than in comparison to the full-fledged states. So, in case of the union territories, certain bills can be presented only with prior permission of the lieutenant governor. Lieutenant governor also has power to refer certain bills to the president. So hopefully you got the approach how to write the answer, because if you will write just enumeration of facts, it will be very difficult for examiner to actually read your answer. It creates a lot of difficulty. Okay. So these are certain aspects. Right? So you can, for your convenience, I have put it here like subjects mentioned in public order and police, and as per the new regulations, because besides the law, government also brings regulation. Now, services also fall exclusively security, public order, and all India services, they fall exclusively under the jurisdiction of the Lieutenant General. Now, Attorney General question, I will not handle much because it is very factual, but let me see, I'll give you the approach. The Attorney General of India plays a crucial role in guiding the legal framework of union government and ensuring sound governance through legal counsel. So he is a first law officer assisted by the Solicitor General. It is a constitutional provision. Its role is to give the consultation. Its role is to represent the parliament, or sorry, to represent the union government in the courts. He has a power of, like he has an audience, he can attend, he can be a member, sorry, he can be participant in the committees, etc. You can discuss how he is appointed. It is a political office. So roles, it's a straightforward question. Responsibility is to represent, to give advice. And limitations. Limitations is he can do the private practice, but he will not take any case against the government. Fine. So if you compare Attorney General in India and Attorney General in Britain he is seen as a member of the cabinet and has more powers. Fine. So now India-Africa digital partnership is achieving mutual respect, co-development, and long-term institutional partnerships. This exact quote is from the Hindu, and that's why I recommend to read it. But how should you approach it? So always put your knowledge in perspective and explain the theme. So what is the theme is that you can talk about when Prime Minister Modi went to Uganda, he gave the 10 guiding principles of India-Africa relationship, and he believed that, and he asserted that our destinies are interlinked. Our former External Affairs Minister, Sushma Swaraj, late Sushma Swaraj, also held that Africa is our mother continent. And from the very beginning, we have gone for India-Africa partnership. In 21st century, we have given the institutionalized turn with India-Africa Forum summits. Africa is important not just for its market or resources. Africa has important geostrategic value because of the proximity and the region, which is a major region or channel for trade. There are the problems of failed states, piracy, etc. Besides the non-conventional issues like climate change, solar energy, and many other things. So India-Africa partnership since 21st century has been given the new momentum with institutionalized interaction, and India is working on its comparative advantage, and today India is using its digital public infrastructure and these goods not just with Africa, with so many countries. So wherever Prime Minister Modi visits, we do see this digital partnership, whether it is RuPay with UAE or with the countries of Pacific Ocean. And this institutionalized partnerships with Africa is very old. We have institutions like, or the frameworks like Team 9, we have ITEC, we have other platforms, okay? And now in the long term, what we are seeing that we are entering into the digital partnerships with the countries like Ghana, the countries like Namibia and others. But the question is not that you tell the facts, but the question is you establish. It is achieving mutual respect, co-development, and long-term institutional partnerships. And the guiding principles are the Prime Minister's 10 principles. And we believe that our destinies are linked, our past is linked, our present is linked. And we have always seen, like if we talk about Gandhi, Gandhi held that the relationship or exchange between India and Africa will not be just of commerce. It will be the exchange of people and ideas. Okay. So this mutual respect is everywhere. We can see India has brought African Union in G20. This reflects this reflects the institutional approach we give, the co-development and co-development, because India is helping under ITEC these countries. India is helping these countries under Team 9. ITEC is the most important platform. Fine. And you should understand why we should have institutional partnerships. Institutional partnerships reflect robustness. It brings stability. It reflects the strategic vision. So you should understand what is and what is its importance. For your facts, I have given this article. Fine. So Pan-African E-Network from very beginning 2009, Togo, Zambia, Namibia, Ghana, these are certain countries. You can see the further detail. Now, with the waning of globalization, the post-Cold War world is becoming a site of sovereign nationalism. So this is like, I believe, any political science student can do. So I always tell, first of all, explain the concept of globalization. Fine. You can talk about Marshall McLuhan, Kenichi Ohane. Conceptually speaking, they talk about borderless world. And then you talk about sovereign nationalism linked with the territory and identity. So the end of Cold War in its first phase was the age of globalization. And when we see the institutions like WTO and other regional organizations proliferated, regimes proliferated, the platforms like International Criminal Court, etc., came into existence. So the globalists like Kenichi Ohane, Suzanne Strange, they all held that there is a dilution in the sovereign nationalism. But as the globalization is based on the unequal exchange, and we see it has given rise to interstate and intrastate disparities, then the backlash against globalization is started. Along with that, the call for sovereign nationalism, though not directly linked to globalization, but definitely linked to the geopolitical interests of the major power. We see that at present time certain problems, the biggest being the migration, the refugee issue, and of course the changing economic gravity from the west to the east are among the so many causes that we see the rise of sovereign nationalisms. You can talk about Brexit, you can talk about America first, and along with conceptual, you should also be discussing through the empirical details and data. Fine. So yes, it is a site of sovereign nationalism. It is reflected in anti-immigration laws. It is reflected in the rightist parties coming to power. Surprisingly, we see that even the liberal parties and the socialist parties, the Labour Party in Britain, is talking about the strong anti-immigration laws. So this is how, means what does globalization reflect? Borderless world. But what is happening? The borders are becoming more and more stringent. And the process started first in the form of putting restrictions to counter the global terrorism. And then came Corona, and then the present phase of anti-immigration sentiments. So I don't think it's a difficult question, but obviously your answer should look mature. Your answer should give this, that you are writing things with ease, you understand the things. I think this is a bonus for the PSIR students. So now, constitutional morality, my favorite topic, and also in the context it is being asked. So constitutional morality is the fulcrum which acts as an essential check upon the high functionaries and citizens alike. So the idea of constitutional morality, it enters into India's political and public and judicial discourse, especially after Ambedkar's speech to the Constituent Assembly, where Ambedkar mentions that no constitution is good or bad. It all depends upon the persons holding the position of power. They have to act with the sense of constitutional morality. And he referred to the statement of George Grote, where constitutional morality has been explained as extreme reverence towards the form of the Constitution. In this speech, he specifically mentioned that the persons in authority, like political parties, judges, opposition parties, constitutional dignitaries, they will have to follow the Constitution in the letter and the spirit. In Ambedkar's description of constitutional morality, he goes beyond the George Grote. And he also talks about that since Indian constitution is transformative constitution, the principles of justice, liberty, equality, social and economic justice, this itself should also be the criteria. And in recent years, the constitutional morality has emerged as a very new and very forceful doctrine of judicial review, next only to the doctrine of basic structure. It has been used by judiciary in different cases, sometimes to establish the rule of law. For example, in the Narula case, where judiciary has used it, in Delhi LG versus CM case, judiciary has reminded about the constitutional morality, as well as in the spirit of transformative constitutionalism, it has referred constitutional morality in Navteej Singh Johar case, it has referred to it in Shaira Bano case, it has referred to it in Joseph Shine case. So this is how you can build its relevance. So explain the concept of constitutional morality. Fine. So constitutional morality and its applicability to ensure the balance between the judicial independence and judicial accountability in India, because some people feel that constitutional morality can be the second doctrine of basic structure, because the constitution itself does not define the constitutional morality. It does not have the term constitutional morality, it has the term morality, though the idea of constitutional morality is implicit in the written constitution. There are three places where morality is used, and judiciary has interpreted the morality given in Article 25, I think Article 19 and 26, to interpret the constitutional morality, human dignity, and equality. So the idea is there are critics like Manu Singhvi who believe that it can be another uh, approach where judiciary can, it creates a scope for judicial overreach, limiting the powers of the legislature. So because of its open-ended nature, and as Supreme Court is using it on case-to-case basis. Okay, so you should understand and understand the underlying debate. And when you discuss the constitutional morality, bring both the two perspectives, the perspective of Grote as well as Ambedkar. Okay, so now, pardon? Judicial independence means judiciary is independent, and judicial independence itself is a guarantee for constitutional morality. But judicial independence should not be interpreted by judiciary as judicial sovereignty, because ultimately it is the government, it is the constitution which is sovereign, means there are inbuilt checks. So judicial independence is based on that fragile balance of power, and judiciary must also act with the constitutional morality. Some people may say that Supreme Court's judgment in Keshwananda Bharti case is where judiciary is acting as a super legislature, not itself adhering to the constitutional morality, and now giving more broader doctrine. Judiciary has to set up its accountability. Like people say that judiciary should not keep doctrine of basic structure open-ended. So similarly, they say that constitutional morality should also be defined. Ultimately, what? Because in some cases, there has been a case where judiciary has not applied the same principle. So sometimes unpredictability also comes. And if doctrine of basic structure is still limited, like under which you only review the constitutional amendment, but constitutional morality is much, much broader, right? In a way, doctrine of basic structure to be used only in interpretation of amendments, but constitutional morality to be used in a much, means some people believe that where doctrine of basic structure cannot be used, judiciary may, in the name of constitutional morality, may increase its powers. So judiciary's interdependence have to be understood, that independence is all about accountability and it is not judicial sovereignty. Have you understood this? So now Indian constitution has conferred the amending power on the ordinary legislative institutions with the procedural hurdles. Ordinary legislative institutions means parliament, because in certain countries like France, there are special bodies, special councils, special courts to look after the amendments, but we do not have. So in India, the parliament has played the dual role. First, as a constituent assembly, full-time and interim parliament, now parliament, full-time parliament and interim constituent assembly, right? With few procedural safeguards. So that's not right to say so, because we do have the procedural safeguards. So first of all, in this question, you should explain the rationale behind amendments. So as political systems evolve, the aspirations of the people change. Ordinarily, constitutions are supposed to be rigid, because it is said that constitutions are not written with ink, they are written with blood. But all constitutions contain the process of amendment. An Indian constitution is a blend of the flexible and the rigid. Certain provisions of the constitution can be amended in a very flexible manner. For example, reorganization of states. For example, fifth schedule and sixth schedule. But there are certain provisions for which the procedure is rigid, and the amendments and the areas with implications for the federal structure, the procedure is further rigid because consent of not less than half of the states is also required. Fine. So you explain that there are few procedural hurdles. What are the procedural hurdles? Getting the special majority. In case of certain states, getting the special majority or getting the majority from the state. So under Article 368, you can talk about it. In view of this statement, examine the substantive limitations on the amending power of Parliament to change. So the substantive limitations come because of the doctrine of basic structure, because judiciary held that Parliament cannot amend the constitution in the manner that it becomes rewriting the constitution. So it is substantive. Substantive is what? Substantive is the realization focused. So judiciary as a guardian of the constitution has put certain substantive limitations in the form of the doctrine of basic structure. Though 42nd Amendment Act adding clause 5 and 6 in Article 368 tried to end these substantive limitations brought by. So by substantive limitations means procedural limitations are what? You have to follow the procedure. Fine, 2/3 majority. But substantive limitations are introduced by judiciary in the form of basic structure. And therefore, when you talk about substantive limitations, you can say on the amending power in the form of basic structure, because why it is not procedural, because any procedure is not required. It is judicial interpretation that is defining it. Okay. So I think you can manage this. Okay. So let's move further. Discuss the evolution of the collegium system in India. I will not discuss the cases, everybody knows. Critically examine the advantages and disadvantages of the system of appointment of judges of Supreme Court of India and that of USA. So what is the present system of the appointment of the Supreme Court of judges of the Supreme Court of India is the collegium system, where judges are appointing the judges. Though in the fourth judge's case, like when Supreme Court held that NJAC is violative of the doctrine of violative of the basic structure, judiciary thus provided the memorandum of procedure. It took lot of time, and often because it may happen that judiciary and executive, they are not sharing the good relations. There may be unnecessary delay, though it is better than a scenario where the judiciary and executive, they are working in tandem. So you can discuss the procedure, and the basic objection as raised by Ambedkar in the Constituent Assembly itself is that there cannot be a state within a state. There has to be checks and balances, and yet we have not been able to arrive at the new procedures, just like it exists in the countries like Britain, in the countries like Africa, Canada, where there is a commission. It means there is a problem and there are valid objections. And so far, this much needed reform has not been done. The government brought an amendment, but it was like the medicine worse than the disease, because it was also impacting the independence of judiciary. And You should also be writing about the importance of the judiciary. It is said that you can write about Dicey's statement, who says that there is no better test of the excellence of the government than the functioning of its judicial system. The rule of law depends upon people's trust in the judicial system. Now, if I talk about American system, it is also not good to follow, because what is the American system? In American system, legislature has a power. The American system is, the name is nominated by president, and then there is a system of higher appointments. They require ratification by the senators. So senator has its own scrutiny committee. And the problem here is that politicization, greater politicization is possible. So you need a golden mean. You need a better system. So neither Indian system is free from its flaws. It has come as a temporary measure pending the long-term changes, but it has almost become permanent. So judges appointing judges go against the principle of the separation of powers. At the same time, giving greater role to the legislature, that is Senate, leads to politicization. So what should be the approach? We should go the way Britain, Canada, South Africa, by creating a commission which is more, more transparent, accountable in its functioning, which gives merited dues, and where the recruitment process is based on merit, not on extraneous considerations, and where accountability and transparency is maintained. So this is how you should be answering this question. So how can you write good answer? You can write good answer only when you go to the examination hall with a free mind. Just have some muscle memory, but it doesn't mean that you start fitting the answer to the knowledge. This is the mistakes a student do. Instead of looking at the demand of the question, what they want, somehow fit whatever they know in the answer. Whether it is required or not, they are not able to give this sense to the examiner that you are confident. By looking at your answers, anybody can say it is an answer written with fear, lack of confidence, sense of insecurity, or it is an answer which reflects your understanding of the principles on which the political systems are based. You need not to mug up the facts. That's not required. That is available anywhere. But what is not available is your critical thinking, putting the things in perspective, ability to analyze the things. Right? So now, evolving pattern of center-state financial relations in context of the planned development in India. So you can talk about federalism. What is federalism? So again, you can refer Dicey that federalism is a political contraband where the units desire unity without uniformity. Normally, federalism is suitable for the large and the diverse countries. And this is how you can write. You can write that because federalism is a dual government. You have the national and the subnational governments. Then, in case of federalism, written constitution and independent arbiter is essential. Now, when you discuss the federal systems, the federalism can have different dimensions: the legislative, administrative, judicial, and fiscal. So fiscal dimension of India's cooperative federalism from the very beginning has been tilted in favor of center. There are provisions like Article 282, which gives the discretionary powers. there are the provisions like Finance Commission, which hardly has the explicit representation of the states. So, considering the regional imbalance and inequalities, not only India went for the planned development in the initial decades, it also has given greater say to the federalism. And what is our, like, what type of fiscal federal arrangement we have? We do have the horizontal and vertical imbalances, where the where you can say that the center's power has more. The nature of taxes under the center, they are not only high yielding, they are also very flexible, whereas the taxes under the state governments are too rigid. And you can also mention about that uh, the type like the resources, and the center has more borrowing powers. It can borrow from outside, whereas there are restrictions on the borrowing powers of the state. India's fiscal federalism has not been static from the very beginning. Then what we see, further centralization trends when the changes in the excise and other aspects has happened, and center got more say. Then with the introduction of globalization, the fiscal federalism entered, because as integrated market becomes important for the ease of doing business, we have introduced GST. GST has not only impacted states' power with respect to their autonomy with respect to the sales tax, which was their most highest yielding tax, but also the power of the local self government. From my point of view, the biggest challenge is that it increases the dependency of the local self governments. And again, as we are integrating and our economic model is changing, so certain regulations like fiscal, regulatory and budgetary management act, etc., from time to time, like states have made a complaint, means that often in finance commission's recommendations, uh, the states which have done better in context of the family planning, etc., they have been at disadvantage. So there are not many problems. There are so there are multiple problems. So the reforms, the biggest reform is the GST reform, and GST has significantly, it may have increased the revenue of the states, but it has significantly decreased their autonomy. Fine. So, what is the principle of federalism? However, we have to understand that Indian federalism is very different from American federalism, which is of the centripetal in nature, which is centrifugal, whereas our federalism is centripetal. So, how will you answer this question? There should be a class and the quality and the understanding in your answers. So, now I am leaving the governance question. So, energy security constitutes the dominant kingpin of India's foreign policy. Why? Because India is an emerging economy. India aims to become the developed country, Viksit Bharat, by 2047. So we need consumption of energy. We need a lot of energy to put our economy, to our industries. And obviously, still, if you compare the per capita consumption of energy in India is still less. So if you are on the path of that, and again, we are becoming one of the leading importers of energy, India and China. And therefore, if you talk about security, the security in the 21st century, we can talk about Barry Buza, who suggests that now there is more importance. A foreign policy has to give greater importance to the non-conventional security issues, and energy security is a very important, rather most important, non-conventional. So what India has done in the past, India has diversified its partners. Today, we are not dependent on just Gulf. We are taking oil from Russia, we are taking oil from US, from Latin America, gas. Plus, we are not just limiting ourselves to the hydrocarbons. We are going for the renewable energy sources. And India has taken not many commitments as Glasgow Summit and subsequently also. So how are we going to deal with the matrix of the security policy related to energy? And we do often face the challenges, for example, the tariffs by Trump. We do face challenges in the free flow of energy because of the uncertainties in Red Sea, etc. So right now, if we are talking about the security policy, it should be a very, very multi-dimensional approach. So you can talk about energy security and is linked with India's overarching influence in Middle Eastern countries. Why India has an overarching influence? Today, Saudi Arabia is improving relations. Today, UAE is improving relations because we are the major consumer, we are the major buyer. How would you integrate energy security with India's foreign policy trajectory in the coming years? What you are going to do? First of all, non-conventional energy sources, because we have to fulfill our commitments at Paris Climate Change Agreement. Besides, India is a responsible country. So I will take more and more steps towards non-renewable. We will go for diversification, more strategic assets. We can have better talks with the countries of Latin America and other countries to build our strategic reserves. So you can mention these type of things. So IR questions are too simple. Each time we do discuss about UN reforms, and the reform process in UN remains unresolved. So first of all, how should you write the answer? You should tell about the rationale of the law reform. So reform is very natural in the evolution of any institution. Otherwise, it will become stagnant and it will not be able to fulfill its mandate or to meet the current responsibilities. Instead of just uttering the facts, write about the rationale, the philosophy. Do you understand the importance? Now, importance of UN reform, because UN is still the core and the highest institution of the global governance with the universal membership. And today, what you see that the world is facing numerous challenges, and we require actually not less but more global governance. But UN is facing the crisis of legitimacy because we cannot meet the challenges of 21st century with the institutions of 20th century. So try to write and give your theme, but let us see the question also. Now, reform process is long pending. We have seen that the reform process includes, the most important is UNSC reform, besides reform of General Assembly, ECOSOC, and other association, financial reforms. But because UN Security Council is the nucleus of the center, nucleus of the system, this is the most important reform which is pending since 70s. From 1991 onwards, the structured process. Right now, where this process has led, it has led to only the draft based negotiation process. But everything has got impacted because of the great power East-West conflict. And unfortunately, it is not just West versus Russia today. It is Russia and China versus West. So it seems that not very optimistic times, the consensus about among the major powers is not going to happen. And we can also say that what is stopping the reform process is not just the East-West rivalry and entanglements, but also the regional rivalries. There are certain obvious questions which are yet to be solved, means who are the members, what will be the criteria, of the membership and many other unresolved questions. There are the problems like what should be the method, as the coffee club is emphasizing on the consensus, whereas India and G4 countries talk about the majority. So there is no consensus. We do have the draft based negotiating process, but no formula is clear how many members, what will be the procedure, who will be the member, and so on and so forth. Fine. So unfortunately, you can write that we have to ensure institutions of global governance. Global South need it more. And we do have an option to create an alternative structure, but UN is there. What is required is reform, but it appears to be the distant dream. So hopefully you have understood what should be the approach and the underlying message, and answer the questions in a way that examiner would like to read. Okay, and how will I put the questions paper? Is it difficult or easy? It depends upon how you have studied, what is your level of preparation. So it will be very unjust as a teacher of political science teaching these papers or studying political science and polity for years and years to dare to say it is a simple paper. So we also need to look through the eyes of aspirants who are new, who are exposed to all these things just for an year or two. So from their perspective, I cannot say it is easy, I cannot say it is difficult. You have to decide, but our endeavor is that you understand the crux of the things, you understand the approach, and I believe that we have been able to do that. So we'll look for your comments so that we can later, like we can also serve you better later. Thank you. Jai Hind, Jai Bharat.